Good evening, everyone. Shruthi, I hope you're ready. Good evening, everyone, and welcome to the 103rd session of the Bar Council of Kerala's Seminar Committee's Continuing Legal Education Series. Today we have with us Advocate Shruthi Manohar, who is now a research scholar at the Cochin University of Science and Technology School of Legal Studies. She is pursuing her PhD in the very subject which she is going to talk to us about, the Insolvency and Bankruptcy Code of 2016. As we all know, the intention of this seminar series is to bring us awareness of different aspects of the legal profession, which most of us may not be familiar with in our usual legal careers. So, once again, let me remind you, those of you who are newcomers to the program, of the ground rules of our session. Please keep your mics muted while the speaker is speaking of the subject. You can ask your questions if the speaker feels during the program, otherwise after the entire session is over. So without much more ado, let us go into the program. Ladies and gentlemen, Shruthi Manohar, research scholar, CUSAT.
Good evening, one and all. At the outset, I take this opportunity to express my thanks to the organizers for giving such an opportunity. Thank you, sir. I'd like to share my screen. Hope the screen is visible. Today, I'll be talking on the topic that's an overview of Insolvency and Bankruptcy Code 2016. In fact, the topic, the particular area is very vast, and I don't know how far I can show justice to the topic within the prescribed time limit. However, I'll be trying to give a very brief overview of the subject, considering the subject, that is the subject is very vast, that is the problem. So when we are talking about the insolvency laws, this is not the insolvency laws are not very new to our country. The issue was that the laws that we had here was multi-layered and fragmented. So there were different forums and different laws which were dealing with insolvency and bankruptcy. And for that particular reason itself, there were different difficulties which we faced while dealing with the insolvency legislations. Since the forums were different, the laws were different, it was multi-layered in that particular sense, and it was fragmented, and there were overlapping jurisdictions. Apart from that, there were systematic delays, procedural delays were there. And there was a concept of debtor in possession, which actually, again, contributed to the position of delays. So altogether, the process was very complex. Being an economic legislation, what is the relevance when we are speaking in terms of the relevance of insolvency laws? What is the relevance of laws is very important. Now, so far as that is in the purview of economic importance, insolvency law actually plays a very important role, because if you are considering the case of an investor, we need a mechanism or a system wherein that would promote the doing of business or promote the investors to come in. So for that, we need an easy entry, that is for the businesses, and for them to continue and to flourish. Likewise, there should be a mechanism which would help those business at a particular point of time. If they feel that it is difficult to continue, they should exit. So the ecosystem must be in such a way that the position, that is the system would be in a position wherein it would promote business. Likewise, it would help in continuing business. And the same importance must be given for the exit. So the laws what we had here in India was such that it was not helping the business to get out of it. That is the basic principle of a good insolvency law, is that it should promote business. Likewise, it should give an opportunity for the businesses which are not viable to exit from that. So the system should be in that way, that is it, which would promote viable business, and the unviable business must be in a position to get out of it. So all these things actually demanded for having a system wherein it should be a situation wherein it would help, or it would promote everything, that is the businesses in such a way that it will ultimately lead to that is economic development. So under this background, there were actually different committees which were constituted. Actually, there were committees which had, in fact, proposed for having a separate legislation. But somehow it got delayed. And it was until the formation of a BLRC, that is a committee which was headed by Dr. Viswanathan, Bankruptcy Law Reforms Committee, which has actually made comments on which has studied for having a comprehensive code in itself. So this is the background of those. So one second. Sorry, there was some technical glitches. Kindly excuse for the same. So I was talking upon the relevance of having a insolvency law. So the need for having, that was I was talking about, need for having a need for consolidating the laws. So like I've mentioned, the laws what we had here was fragmented. So it had its own difficulties. Like, for example, like I have mentioned, different forums, different jurisdictions. So all these were the situation. So now a consolidation was necessary. It was felt and a committee was constituted. That is the Bankruptcy Law Reforms Committee was constituted, and it is through that is finally, like I've mentioned before, even before, different committees have mentioned about the need and relevance for having these insolvency laws, but specifically to deal with these issues, the BLRC in short, that is the Bankruptcy Law Reforms Committee was constituted, and which has ultimately led to the enactment of Insolvency and Bankruptcy Code. Now the resolution, like the terms like insolvency, bankruptcy, liquidation, right? So when we are talking about these things, insolvency means it is actually the inability to pay the debts. Now, it is the inability of a person or a corporation to pay their bills. That is when they becomes due and payable. Bankruptcy is a situation wherein the person is declared incapable. So there's a declaration, declared incapable of paying their bill. And liquidation is the process of winding up of a corporation or of an incorporated entity. So the laws what we had here before was actually not providing a situation, or it was not enabling to give signals, that is early signals of insolvency. The thing was that once be it a company or partnership, whatever, once it reaches the that is when it is in a difficult situation, only then, that is once the insolvency happens, it is that position wherein the law comes into. So again, there were delays, and all those has led to the that is erosion of the assets which were left out there. So the position must be like this, that once it is understood that it is difficult to move on with the business, it should be in a position to stop it, to wind up there. And the assets, what is left out there, must be taken out. That is, it has to be like distributed to the existing creditors, and the rest has to be, that is, the money has to come out of that particular place where it has been kept hold. So it should be in such a manner. But the situation of the laws, what we had before, did not promote that kind of thing. That the unviable businesses were kept on, they had to, the delays were there, the procedural delays were there, all those things put and got stepped. So the resolution was taking that resolution, that particular term, like I've mentioned, resolution was actually impossible, and the process was too much delayed. It took about 4.5, that is on an average 4.5 years in India when it comes to the case of resolution. But when we are comparing it with the other places, like for example, in UK or the Singapore and all, the time taken for the resolution, that particular process was now like on an average, it took only like 1 year or 2 years. But in India, it took that much delay was here. So all these things actually made it difficult for the ease of doing business. And in the global index also, India was ranked in a very bad position. That is out of 190 countries, India's rank was then at that time, like in 2017 and all, it was like 136 position. Now, so all these shows the position of laws what we had here to deal with insolvency and bankruptcy. So all these things led for the need for having a comprehensive law. So when we, it could be seen that if we are analyzing the evolution of insolvency laws, the laws what we had here was like for dealing with individual insolvency, they were separate laws. To deal with corporate insolvency and partnership laws, yet another group of laws were there. So like I've mentioned before, there were multiple laws. For example, to deal with individual insolvency, we had Residency Towns Insolvency Act, then Provincial Insolvency Act. Then for the other, like corporates, for the companies and all, we had other laws like SIC Industrial Companies Special Provisions Act. Now this SICA, This particular law was meant for actually for reviving the companies. That is, it was meant for certain categories of companies who are actually industrial companies which were in distress. So revival mechanisms were brought in through this particular. That is, it was meant for that particular thing, for the revival, rehabilitation and all. However, the act proved to be a failure in itself. One of the reasons was that there were moratorium provisions, and the possession of the assets of the that particular distressed companies were with the debtors. So ultimately, all these things led to the delay. Now, something was left with that particular company that got eroded by that time. So ultimately, that law by itself proved to be a big failure. So the fruits of for what the law was made did not give the fruits for what it was intended. So it was an utter failure. Now, there were other laws like for the recovery, there were recovery laws like the Recovery of Debt due to Banks and Financial Institutions Act. Then SARFAESI Act was there, that is Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. Now, apart from that, when it comes to the case of companies for the winding up liquidation and winding up procedures were provided under Companies Act. So it was under Companies Act of 1956. Companies Act 2013 actually replaced the Companies Act of 1956, but the provisions for winding up and liquidation was not notified. That is 2013 Act under 2013 Act. So in practice, 1956 Act provisions were actually put in, and in fact, by that time, IBC came into effect. So anyhow, we can say that when it comes to the case of Companies Act, nowhere it has mentioned about the term insolvency. There, what it has been mentioned is that inability to pay debt. So if there is an inability to pay debts, there were there were provisions for liquidation. So there was no other option in the sense once we are filing for liquidation or winding up, ultimately the company must go out. That is, it comes into exits. However, the time period was again there were way too much of delays in that. Now, apart from this, there were other schemes of RBA, that is CDR, SDR, like that. That is corporate. And that is for the that is as a mechanism for resolution. Now, so like I've mentioned, it is the Bankruptcy Law Reforms Committee, which was under the chairmanship of T.K. Viswanathan, and it ultimately submitted its report, and the president's assent was received on May 28th, and the law was made. That is a draft code. Insolvency and Bankruptcy Code was made considering the global scenario as well. The UN ancestral model laws were also taken into consideration, and in line with that, that is as a competent, globally competent law. That is what is necessary as a basic principles of insolvency legislations were all taken up in this particular legislation, and finally the law was enacted. Now, the law came into existence on December 1st of 2016, and the very objective, when we analyze the objective of this particular law, it could be seen that it has actually brought in the legislations, like we have seen in the earlier slides. There were too much of legislations for dealing with individual insolvency, likewise for corporate insolvency. So all these things were merged, in the sense all these things were brought in with a new things which were actually very new to India. That is, there were different new concepts which were brought in. So basically, this particular law has consolidated the laws relating to insolvency, So now this particular law, that is the Insolvency and Bankruptcy Code, actually covers the individual insolvency. Likewise, the corporate insolvency is covered under this legislation. So the main objective, which has been stated in the preamble, is that it is a resolution. So the law is meant for resolution, reorganization, and resolution. It is not a recovery law. It cannot be used as a tool for, or it cannot be seen as a tool for recovery. The concept is resolution. That is what the law is trying to highlight. So resolution and then maximization of value of assets. It's maximization of value of assets in the sense earlier laws had actually brought in many, that is procedural wise, there were too much of delays. So these delays led to the deterioration of the asset, that's the value of the assets. So this erosion of value in every sense, it was bad to the economy. So here the concept as the basic principle of a good insolvency law, the maximization of value of assets is very much important. So the code or this particular law has highlighted that relevance, and it has been made with the objective of this maximization of value of assets. So this principle has been kept throughout. So with this particular concept or with this particular objective, to promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders. So different stakeholders would really be the creditor stakeholders. So far as a company is concerned, if it goes into liquidation, what happens is that it actually affects every sector, be it an employee, be it a creditor. So all these persons are affected. So ultimately it is affecting each and different types of stakeholders. So like I've mentioned before, the system must be like that. If it is a viable business, the financial distress is something which we cannot be avoided so far as the business is concerned. But there should be some kind of legal mechanisms which would help in promoting the business. That is, if the viable ones, if they get some kind of financial assistance, they may be able to continue their business. So the business might be viable, but the situation is that the financial constraints. So if it has been cleared up, so some kind of mechanism for the reorganization or rehabilitation is provided, means they can continue with that business, which means that the different stakeholders won't be affected. So the business would be going on. Whereas if it is an unviable business, there is no point in continuing. It would only affect that is whatever is left in that particular business would be eroded. So unviable business must be in a position to get out of it easily. So that is what I'm trying to point out. That is, viable business must continue, whereas unviable business must be in a position to get out of it. So the legislature or the insolvency laws must be in such a way that would promote easy exit of the unviable business and reorganization of the viable businesses. So that is what the law is trying to bring out. So in between that, the process would be in such a way that would ultimately lead to the maximization of value of assets. So as a going concern, or that is, the business must be going on, whereas the resolution process must be going in hand with that. So the Insolvency and Bankruptcy Code is trying to put that is, the law is trying to ultimately what the law is aiming us to is for resolution and maximization of value of assets, and thereby to promote entrepreneurship and making the credit available and balance the interest of different kinds of stakeholders who are involved in it. Now, when we are speaking about the applicability, like I've mentioned, earlier laws were like, for individuals, they were separate laws. For corporates, they were separate laws, right? So now all these things have been brought under a single umbrella, a single legislation. Now, Insolvency and Bankruptcy Code entails, or it is made applicable to corporates as well as individuals. So it is applicable to companies which has been registered under Companies Act and others. Likewise, limited liability partnership, then partnership firms and individuals. And with this law, that is by the enactment of Insolvency and Bankruptcy Code, several other legislations were amended, like 11 different legislations were amended with the with this particular, that is enactment of this particular code, and individual insolvency laws are repealed. But as of now, the position is that with respect to individual insolvency, only a particular portion has been notified. All other things are yet to be notified. That is in case of individual insolvency. The notified area is that when it comes to the case of personal guarantors, that is to the corporates, only with respect to that particular part, the individual insolvency has been notified. Rest are yet to be notified. And when it comes to the case of other things, that is a corporate insolvency is in force. Now, when we are analyzing the scheme of the code, it could be seen that the law has been, insolvency and bankruptcy code has been divided into 6 parts. That is first part dealing with definitions and everything. The part 2 is dealing with insolvency resolution of corporates. So that is actually in actively, this particular portion is now being followed. And part 3, that is with respect to individual insolvency. Now it is about with regard to this particular part that I've mentioned. Individual insolvency has not been notified, except that in the case of personal guarantors to the corporates. Now, part 4 is dealing with the regulations of insolvency professional, then insolvency professional agencies and information utilities. In fact, this is something which is very new to the insolvency laws, because here we have that is, it has been made possible through the IBC that we are having professionals who are dealing with that is earlier we had liquidators, but now these things have been marked for certain categories of professionals. Now these professionals are insolvency professionals. So for the purpose of resolution, earlier what the liquidators had done, official liquidators had done, now that particular role has been taken over by these professionals. Now this has been made possible through this particular code, and for the regulation, certain bodies have been created, and like that is for the whole of the code, or for all the above that, there is a major regulator, that is a board has been created, that is Insolvency and Bankruptcy Board of India. And likewise, yet another institution is an information utility. So which about these things I'll be dealing in the next slides. So if you're analyzing the features of this particular new law, one thing is, the major thing which has to be highlighted is the maximization of value of assets. Like I've mentioned, the core idea or one of the basic features of the this particular laws for maximization of value of assets. And the other thing is that all these things have to be made in a time-bound manner. So this time-bound mechanism has been made possible. But practically put, there were certain difficulties while following strict timelines. So there were some kind of difficulties which were faced during different phases. However, the legislation has been proactive. That is, amendments were brought in to deal with. Even now, they are trying to bring in certain amendments so as to make that particular time mechanism to be a time-bound one. Now, yet another feature is that when it comes to the case of the possession of that particular debtor, that is, earlier regimes were in such a manner that the debtors were in possession. So that would create difficulty for the creditors while enacting or while exercising their rights. So this particular legislation has bring a drastic change. This is something which is very new to India, because we never had a law wherein it promotes or wherein the control has been given to the creditor. Now, under this particular legislation, debtor in possession concept has been changed, and now the creditor gets the control of the this debtor. So there is a shift, that is from debtor in possession to creditor in control. Likewise, it ensures, like I've mentioned earlier, it is trying to balance the interest of different stakeholders. The priority when it comes to the case of payment, that is priority of payment at the end of the whether, like for example, if you are taking the liquidation, if a company is unviable and it has to stop its business, so it is if it is going ultimately to the liquidation, now the proceeds will be distributed. So in that distribution of proceeds also, drastic differences have been brought in. Earlier, the government dues were given priority. Now, all those things have been changed, and the government dues have come. That is a prior in the payment priority. Certain what of mechanisms have been brought in, and that has also been made in such a way to ensure that the interest of different stakeholders are ensured. Now, the other peculiarity is that here we can have a understanding, or the insolvency can be detected at an earlier stage. There is no need to wait till the assets are eroded. If there is because the code is drafted in such a way that earlier the position was that, like, if there was inability to pay and all, now the thing has changed. Now, if there is a default with a prescribed threshold has been maintained. So if there is a default, now it is like 1 crore rupees. So we can initiate the process under Insolvency and Bankruptcy Code. So we can so that actually gives a step, or it is a step forward actually, because it helps in detection of insolvency and all. Thereby, it can save the businesses. Now, establishment of insolvency and bankruptcy.
The person who is speaking, checking if please mute the mic. Shiji Rebero, please mute the mic.
Okay. So now we have like I've mentioned, there is a board, which is a regulator, that is the Insolvency and Bankruptcy Board of India. This has been established under this particular law. Then we have other mechanisms like for resolution of, to make it, when it comes to case of small companies, fast track mechanisms have been made. Apart from that, voluntarily also the corporates can go to liquidation. Likewise, when it comes to the case of individuals also, on the partnership also, a mechanism has been provided for their resolution. Provisions for, like, there are mechanisms like fresh start process. So all these things are actually aiming at the resolution of persons. So these things are again, which is focused on bringing out that is the resolutions, and ultimately making the maximization of value of the assets. Now we have the specific particular, that is when it comes to the case of individual insolvency, we have the adjudicatory authority, that is DRT, and when it comes to the case of corporates, the adjudicatory authority is NCLT. So now it is not scattered like what we have seen in the previous regime. So we have the adjudicating authority. The difference is this, like when it comes to the case of individuals, it is DRT, and for corporates, it is NCLT. So from appeals from NCLT goes to NCLAT and then to Supreme Court. Now, the other peculiarity or feature of the particular law is that we have professional insolvency, professional agencies, and information utilities. Like I've mentioned before, the insolvency professionals are the resolution who acts as resolution professionals, and they are controlled by the professional agencies. And apart from that, for information utilities are also made under this particular law, which actually gives the information with regard to, just like what we have the CIBIL score and all, no, right? Likewise, with respect to the corporates and all, the information, credit availability things, everything would be there. And right now NESL is a information utility which has been registered with IBBI. So when it comes to the case of proving of default and all, the codes can actually, let's say NCLT can rely upon the informations which has been provided by information utility. So basically the 4 pillars of this insolvency and bankruptcy code is these things. Like we have seen, this is the insolvency professionals, information utilities, then the adjudicating authority, and the IBBI. So this forms the basic 4 pillars of this particular law. Now, when we are speaking about the time-bound mechanism, this timeline is a very peculiar feature of this particular act, because everything has to be covered or has to be completed in a time-bound mechanism. Only then what the objectives, like what has been stated in the preamble, can be achieved. So time is a very essence here. So when we speak about this particular law, like I've mentioned, this is dealing with individual insolvency, likewise corporate insolvency. So I'll be mostly covering this corporate insolvency since it is in force. So corporate, when it comes to the case of
audio mute and mute. So mute.
Dear, let me on the mute here.
So when it comes to the case of this timelines, in the corporate insolvency, actually 2 levels or 2 kinds of mechanism can be seen here. The process is like this. There can be 2 steps. First step is that the law is trying to give an opportunity for the particular business to resolve. So first step is that a provision for resolution has been made. That is, if it is a, like I've mentioned before, if it is a viable business, but only the financial constraints is affecting it, means that if that can be addressed well, then the business need not go to liquidation. So first step is that the law is made in such a way that a resolution can be made. That is, once we initiate the process under the corporate insolvency, the process is meant for resolution. If it fails, mandatorily it goes to the second stage, that is the liquidation. So once we initiate the process under this code, the process is known as corporate insolvency resolution process. So once the resolution, that is once we take or we make an application for initiating the particular process, it has to be completed within the timelines prescribed by the law. So at every stage, timelines have been prescribed. So once it fails, it goes to the second stage of liquidation. Now, this is actually the mechanism what has been provided in this law. So the resolution has to be completed within 180 days, and which can be further extended to up to 90 days and altogether 270 days. Now, what happened is that practically when it came into practice, there were difficulties in following this particular timeline. That is, it was difficult for in many cases to complete the process for a number of reasons to complete the process within 270 days. Meanwhile, there came the stay of suits and everything. So different NCLTs gave different views because since the law was new, and so it was only an evolving jurisprudence. So the different views were given by different tribunals and different benches of NCLT. So an amendment was brought in wherein it was stated that altogether this particular timeline, that is when it comes to the case of corporate resolution, it can be made or it has to be made within a maximum period of 330 days, including all the that is judicial proceedings and all, including all those things. The time limit must not be more than 330 days. So that is when it comes to the case of resolution and liquidation process. That is, first it is the resolution process. If the resolution process fails or if it cannot be achieved, definitely, like I've mentioned, it is like mandatory. It then goes to liquidation. So the resolution has to be completed within this particular time frame, that is 180 plus 90 days. Anyways, not more than 330 days, and then it goes to liquidation. Now this is the process. So we can say that it is in two different steps. First is the resolution. If the resolution fails, then it goes to the liquidation. This is actually the way in which the corporate insolvency has been laid down, or the process for corporate insolvency has been laid down under the code. So this resolution, that is the first step, like I've mentioned. So this first step, that is a corporate insolvency resolution process, can be initiated when there is a debt which is in default. So it is again different from the earlier regimes what we had here. Earlier it was like if there was inability to pay, so we have to wait till that. So that was a different position. Now, if you are analyzing it from the purview of a company, like it was a balance sheet driven and debt driven thing. If you're considering it like that, now the position is that if there is a debt which if is in default, we can initiate the process. So the process is meant for resolution. Only if resolution fails, it can go to liquidation. So there is no shortcut straight like to go to the liquidation. So the position is like this. First, resolution has been, so the law is actually trying to resolve. Everywhere it is trying to save the business if it is a viable one. That is the crux of this particular thing. So always, even at the stage of liquidation also, if there is a position, or if it is a situation wherein the company can continue as a going concern, again, provisions have been made in such a way to make or to promote that. So ultimately, the law is trying to save the company, in the sense to resolve the company. So when we are speaking about this process, that is corporate insolvency resolution process, the threshold limits, if we are speaking about it, earlier it was 1 lakh. Now it has been, with after amendment, now it has been made. In fact, it was after that COVID issues and all. So that during that pandemic time, so the debt, now the threshold has been increased to 1 crore. So if there is a debt which is in default, then we can initiate the process under this particular law. So debt means, now that as it has been provided under this particular law, is a liability or obligation that is with respect of a claim. Now the claim has been very widely defined in this particular law. Likewise, debt is, like we all know, it is a non-payment of debt, whether it be in whole or in part or in installments. So we can see here that the definition has been made in such a way, it is actually very elaborate to bring in all things in the like if you see, or if you look at the definition of claim, it could be understood that is very wide, so as to include everything inside. So now the yet another peculiarity of this particular law is that here like ordinarily we know a creditor, we see a creditor as a secured or unsecured one, but here the law has brought in a difference wherein they have classified the creditors as financial and operational creditor. So again, this is a peculiarity of this particular law. So financial creditor, in the sense to whom a financial debt is owed, that is debt may with or without the interest for the time value of money. So that is a financial creditor. Whereas operational creditor means to whom an operational debt is owed. Operational debtor, in the sense, claim in respect of provisions of goods or services. Again, this is a very new thing to our law, because earlier we had this categorization as secured or unsecured. Here, that is not looked into. What we are looking is whether it is an operational creditor or financial creditor. So the categorization has been made in such a way that financial creditors and operational creditors are given an opportunity to set in forth the motion law. So this particular process or the corporate insolvency resolution process can be initiated by financial creditor, corporate operational creditor, or the corporate debtor by itself. Now, when we are briefly looking at this particular process, that is corporate insolvency resolution process. So like I've mentioned, it is the first step. So the first step is, it is trying to resolve the company. Resolution is the first step. So for setting in, for initiating the process, the application can be, or initiating the corporate insolvency resolution process, it can be initiated by the financial creditor or the operational creditor or the corporate debtor itself. Now, for this particular process, an application can be made to the adjudicating authority. Now, it has to be noted that every stage of the particular process is time bound. Everywhere timelines have been prescribed. So once the application has been made, it has to be admitted within, or either admitted or rejected within 14 days of time. So again, the timelines has been strict enough than there were a number of cases wherein there were confusions wherein it is whether to see if it is these timelines were mandatory or directory and all. Anyhow, it is only directory road. That is what we are following now. It has to be seen that that is once the particular process is admitted, it is like that. If it has been admitted, that is the process is initiated. Admissibility of the application makes things different in the sense, once the application is admitted, they starts a moratorium. So throughout the particular process, the moratorium would be there, and the application, when once admitted, the process is considered to be started. So the corporate then onwards, the timeline of 180 days, like I've mentioned before, starts. So 180 days plus 90 days, if it is extended, altogether within that particular time frame, this particular resolution process has to be finalized. If not, it goes to the liquidation process. So once the application is accepted, the moratorium begins. Then there is an appointment of insolvency, that is a resolution professional. So like I've mentioned earlier, it is different from the earlier regimes. Now we have the professionals who are actually meant for this particular process. So these professionals are appointed here for the, actually they acts as an intermediary between the creditor and the debtor. So the insolvency resolution professional is appointed here. At this particular stage, they act as the interim resolution professional. That is for a interim period, they are acting as interim resolution professional. So once the CIRP process is commenced, moratorium comes in, and likewise interim resolution professional is appointed. Now with the public announcement of this particular process, collection and verification of claims, where claims are invited, and then from that claims, like I've mentioned before, it is the definition is in such a way that it covers almost everything. So the claims are accepted, and from that a committee is constituted. Again, this is very peculiar thing. That is a committee is constituted here, that is known as the Committee of Creditors or COC. Now this committee comprises of financial creditors alone. So here we can see that the application can be given by financial creditor as well as the operational creditor. Operational creditor in the sense, the creditors to whom goods and services are, the creditors who provide goods and services. So this particular operational creditors won't be a part of Committee of Creditors. So the committee which has been constituted would be comprising of financial creditors alone. So it is this particular committee which actually determines the future of this particular company. That is here, like I've mentioned, it is a step one, that is for resolution. So once the process is initiated, it has to be completed in a time-bound manner. So within this particular time frame, the decision will be taken by the Committee of Creditors. So actually the commercial wisdom lies with these particular people. So it is these particular people with their voting threshold prescribed by the law, they actually determines, or they actually sees whether this particular company has to be resolved or not. So for that particular resolution, a resolution plan that is actually from the persons who are actually interested to take up this particular company or to finance this particular company, plans can be taken or can be called for from persons. That is, technically they are known as the resolution plans can be taken from the prospective resolution applicants. So all these things are, the decision making is actually by this particular committee of creditors. So they have a very big role in this. So this particular committee is constituted, and it has to be noted here that now the control has been shifted. Like I've mentioned before, once the process is initiated, the company loses its control. Actually, that has made a deterrent effect on many of the companies to resolve things easily and not to wait or to go to the liquidation and all, because here the company is losing its control throughout this particular period. The company might be going, or it would be continuing as a going concern, but the issue is that the control of that particular company goes from their hand. So this interim resolution professional would be replaced by the resolution professional by the committee of creditors. So once the committee of creditors is constituted, this particular resolution professional, maybe he himself would be continued as a resolution, that is the interim resolution professional can himself continue as a resolution professional, or a new person can be appointed. New person in the sense, again, from this particular insolvency professional only. So a resolution professional is appointed, and like I've mentioned, the resolution plans can be invited. That is, they will the persons who are, or the companies which may be looking forward to this particular company. That is, once the public announcements are made, the processes for resolution, right? So for resolving this particular company, invitations are made. That is, the persons that is who are prospective buyers can look forward. So the prospective resolution applicants can make their application, and for this there are rules and regulations that has been made in, that is, the IBBI has made regulations with respect to different processes, and for corporate insolvency resolution process there are regulations. Apart from that, rules made by the MCA is there. So along with the IBC, the rules and regulations has to be considered. So following all these things, like what has been prescribed, the procedures are taken. So the appointment, once the resolution plan is received, it is put forth before the committee of creditors. So this particular committee of, like I've mentioned, it decides the fate of this particular company. So committee of creditors will look into the resolution plans received, and they can either accept or reject it. So a voting threshold has been put in. Here it is a 66% voting threshold is that. So with that particular threshold, if it has been approved, then this particular plan would be put forth. That is, the resolution professional will take it to the NCLT for its approval. So actually NCLT is just giving a note here. The decision is actually finalized by the committee of creditors. So that is why I'm saying it is the fate of the company is decided by the committee of creditors. So this particular resolution, once it is approved, it is that is approved by NCLT, it is binding on all the parties. So the resolution plan would be implemented, and the effect is that the company continues or it goes on. So here resolution is a success. But there can be situations wherein the resolution plan may not be accepted by the committee of creditors, or the resolution plan is not received. No kind of plans was received. Or they can be situation wherein the process of resolution was not made possible within the timelines fixed by the law. Under such situation, then it goes to the second step, that is the liquidation step. So first step is resolution. Once the process is initiated, it must go on, and definitely it goes to the second stage if the first stage is a failure, or it is decided, or it can be like this also, that is the committee of creditors decides or considers that there is no point in continuing with the resolution because it is very difficult, the business is not at all viable. Under such circumstance, what happens is that they will be considering for going into liquidation. So even though if it is a unviable business, a chance is given to look into if it is possible for the company to go on. If there is a position, if there is a situation for making it a viable one, if so, it has to continue. If not, definitely it should go to liquidation. In the sense, if it is one viable company, it should go to liquidation. So that is the idea here. So this is a process, that is the resolution process. So if the resolution process fails, it goes to liquidation. So it could be seen that here the role of, like I've mentioned, this committee of creditors is very much important. And likewise, the resolution professionals act as an intermediary between the creditor and the debtor here. And it is the adjudicating authority which gives the final note, or it oversees the things in that sense. So this is the process which has been mentioned, that is for corporates. Now I'm actually dealing with the corporate insolvency only. So this is the process for corporates when it comes to the case of companies. Now this the process has been the provisions or this particular part is put both in action. So that is why I'm dealing with this particular thing. Now the other second stage, that is when, like I've mentioned before, if the earlier process, that is the resolution, is a failure, or the resolution, they could not reach a resolution, or the resolution cannot be completed with the timelines prescribed, or if they feels that the company is an unviable one. Under those circumstances, it goes to the second stage, that is the liquidation process. So liquidation process is like this, that the liquidator again is a insolvency professional. Now, there will be an appointment of liquidator and the liquidation estate, that is what the assets of the companies would be considered, which has been considered for liquidation, is known as a liquidation estate. So that would be made. Likewise, the claims would be consolidated. That is the different claims, even at this particular stage, new claims can be entertained. And all these things are made by the are done by the liquidator, and the claims would be verified, and rejection or admission is made then. And finally, the liquidator would make it, in the sense that whether they would see that whether there is any kind of transaction which is that is the debtor has entered into before the particular process has initiated. That is, if there is any kind of transaction which is which has to be avoided. Again, this is a new thing so far as the law is concerned. So such kind of any kind of preferential transactions or undervalued transactions are made. That is, those transactions can be like, for example, they can be fraudulent transactions which was entered by the debtor prior to the initiation of process. So such things can be taken into consideration, and the assets can be pooled in. So for that particular purpose, the provisions have been made under this particular code to verify and see it. So those things are exercised by the liquidator. And finally, the distribution of assets and dissolution of corporate debt is made. So this is ultimately the end of the process. So there is a resolution process. If the resolution fails, it goes to the liquidation process. Now, another peculiarity of the law is that there is a waterfall mechanism, or the payment priority has been prescribed by the law. It is something again which is different from the earlier regimes what we had here. Because if you see here, it can be seen that even the claims of the unsecured creditors are given priority than the government dues. Earlier, government dues were given much importance. Now, the law is drafted in such a way that the priority has been changed in everything. So it could be seen that under the provision, under section 53, when it comes to the case of corporate insolvency, it could be seen that the mechanism or the payment priority has been fixed in such a way that first, of course, it is the cost of the particular process, cost of the liquidator, or when it comes to the insolvency professional, whatever. So that particular cost is covered first. And it has been made in such a way that once it is just like a waterfall mechanism. If for example, if the what is left, that is from the resolution, and after that, if the resolution fails, it goes to liquidation, and the process is going like this, right? So the proceeds of these things would be distributed in such a way that first, the cost of the things would be covered, and second, it would be considered. That is, the workman would be considered. The workman is considered in paribus, or they are in equal footing with that of the secured creditors. So that is something which is again a drastic change, I would say, because they are considered in that is in the level of the secured creditors. So the workmen's dues are considered secondly, along with that of the secured creditors, and then employees' dues are considered, and after that, other unsecured financial unsecured creditors. Only it is after that, after considering the unsecured creditors, the government dues comes in. So that is a drastic change. Then other debts are considered, and then preferential shareholders, and finally, if something is left, only then it goes to the equity shareholders. So this is a waterfall mechanism, what we can see here. So it could be it has to be noted here that the law is the law has actually made a drastic difference from the earlier regime. Like I've mentioned, many things have been brought in under a single legislation. It has been called consolidated in such a way to deal with every aspect of insolvency and bankruptcy. Individual insolvency has been brought in, corporate insolvency has been brought in together under this particular single legislation. And moreover, there are various principles which is very new, that is to the insolvency regime in India. So all these things are actually aiming at, like I've mentioned, for the resolution, or that is ease of doing, the promoting ease of doing business. So ultimately, it is aiming for the economic benefit. So I would say that practically put from the last 5 years, it could be seen that drastic changes have been brought in this particular area. And if in a nutshell, I would say that it is actually a landmark one. And when we are seeing different judgments, these are few of the important judgments in this particular area. And a number of judgments, the constitutional validity was challenged. Being an evolving jurisprudence, like I've mentioned, the law is new, so everything has been tested and done. So the constitutional validity was challenged several times. And to highlight, in the case of Swiss Ribbons Private Limited, it was fixed. And then a number of cases, different aspects were considered, but with the time, within this particular short time, it is very difficult to cover all these things. So I think I should conclude here. So I think I have exceeded the time which has been given by the organizers. So now the forum is open for questions. Thank you.
Thank you, Shruthi. You gave us a lot of information about this act, which is new to several of us. The floor is open for questions. Hello, Shruthi.
Yes, sir.
Can you hear me?
Yes, sir. Yes.
NCLT in the mole, is there any appellate authority?
NCLAT, sir.
NCLT in the mole appellate authority.
Illa, pinna Supreme Court like.
High Court in jurisdiction.
Illa, sir.
Madam,
Yes, sir.
Is there a certain amount of debt to qualify for bankruptcy?
Insolvency, sir. Insolvency, it is when it comes to the case of company, 1 lakh ayirunnu mumba. Now it is 1 crore. That is after 2019.
Madam, you able to hear me?
Yes,
Hello?
sir. Yes, sir. Yes, sir.
So I was asking a question regarding,
Yes, sir.
is there any certain amount of debt to qualify for bankruptcy?
Yes, sir. There is.
What is the amount?
Yes, sir. There is. When it comes to the case of corporate insolvency, it is right now it is rupees 1 crore. Earlier it was 1
This
lakh.
much debt, etc.
Am I audible?
Okay. Audible, yeah.
Yeah, when it comes to the case of corporates, that is for corporate insolvency, the debt must be, that is the threshold is like this, rupees 1 crore. Earlier it was 1 lakh. Now it has been, the threshold has been increased to rupees 1 crore. When it comes to the case of individual insolvency, though it is not notified, it was 1,000 rupees. So there were some confusions, like in the sense, hopefully there would be changes on that, because otherwise it would be very difficult. Like
Whether the bankruptcy eliminate all my debts or all the debts, it will cover all the debts. Bankruptcy will eliminate all the debts of the particular corporate.
Pardon?
The whole debt will be eliminated by bankruptcy process or a particular amount only.
So it is like this, when it, that is, if there is a default, that is, sir, if you are speaking about the corporates, if there is a default, this is the criteria, that is to initiate the particular process. When it comes to the case of corporates, to initiate the process, like I've mentioned before, an option is given for resolution. So for resolving, that is, it is a mandatory step. You cannot go straight forward to the liquidation process. So if there is a debt and if that debt is due, so the process has to be initiated. So for that particular purpose, the debt, that is the minimum criteria, is that there should be a debt which is at least rupees 1 crore. That is 1 crore or more. The debt is in default. If then we can initiate the particular process. And if that particular resolution process fails, it goes to liquidation. Whereas there is another provision wherein if there is no default, pardon, sir. Again, there is another provision under this particular law, that is for voluntary liquidation. When it comes to the case of companies, actually those companies may not have defaulted, but they want to exit from that. So there are certain criteria have been mentioned there also. That is totally a different procedure altogether. That is for voluntarily they can go for liquidation. The thing is that there must not be any kind of debt which is in default. Here it is like this. If there is a debt which that is the amount is like this, right now it is rupees 1 crore or more, which is in default, then we can initiate the particular process.
One question.
Yes, sir. Yes, sir.
And that Anil Ambani was declared as bankrupt. So
Yes,
that means to say that he need not pay any liabilities or claims, etc.
Pardon?
Anil Ambaniയെ ബാങ്ക്രപ്റ്റ് ആയിട്ട് ഡിക്ലെയർ ചെയ്തു. ഒരു കേസ് ഉണ്ടായിരുന്നു സുപ്രീം കോടതിയിൽ. അപ്പോ അതിന്റെ അർത്ഥം എന്താ വെച്ച് കഴിഞ്ഞാല് വെദർ അയാൾക്ക് ക്ലെയിം ലയബിലിറ്റീസോ അല്ലെങ്കിൽ ഡെപ്സോ അത് ഒന്നും ഒരു പ്രോപ്പറായിട്ട് ഡിക്ലെയർ ചെയ്യാൻ പറഞ്ഞിട്ട് കൊടുക്കുകയും ചെയ്തിരുന്നു. അപ്പൊ അതിനർത്ഥം ഒരു ക്ലെയിംസോ കാര്യങ്ങളൊന്നും കൊടുക്കണ്ടെന്നാണോ?
അങ്ങനെയല്ല സർ, ഇതിൽ രണ്ട് രീതിയിൽ നോക്കണം. അപ്പം രണ്ട് കാര്യങ്ങളാണ് ഉള്ളത്. ഒന്നെന്ന് പറഞ്ഞാൽ ഇൻഡിവിജ്വൽ കേസിൽ വരുമ്പോൾ വ്യത്യാസമാണ്. അതായത് അവിടെയാണ് ബാങ്ക്രപ്റ്റ് ആയിട്ട് ഡിക്ലെയർ ചെയ്യുന്ന കാര്യം വരുന്നത്. കോർപ്പറേറ്റ്സിന്റെ കേസ് വരുമ്പോൾ ടെക്നിക്കലി സ്പീക്കിംഗ് ഇറ്റ് ഇസ് ഡിഫറെന്റ്. ടെക്നിക്കലി സ്പീക്കിംഗ് അവിടെ എന്താ സംഭവിക്കുന്നത് എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ കോർപ്പറേറ്റ്സിന്റെ വേറെയാണ് വരുന്നത്. അവിടെ ഇവർക്ക് എന്താണ് ഇത് അടച്ചുപൂട്ടാനുള്ള ഒരു ഓപ്ഷനാണ് കൊടുക്കുന്നത്. അടച്ചുപൂട്ടുക എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ വെറുതെ അടച്ചുപൂട്ടല്ല, കാര്യങ്ങളെല്ലാം സെറ്റിൽ ചെയ്ത് കറക്റ്റ് ആയിട്ട് പോകണം. അപ്പൊ
ലിക്വിഡേറ്ററെ അപ്പോയിന്റ് ചെയ്തിട്ട് കംപ്ലീറ്റ് കാര്യങ്ങൾ കഴിഞ്ഞ ശേഷം മാത്രമേ അത് ഫുൾ ആയിട്ട് വൈൻഡപ്പ് ചെയ്യാൻ പാടുള്ളൂ എന്നാണോ ഉദ്ദേശിക്കുന്നത്?
കോർപ്പറേറ്റ്സിന്റെ കേസിലാണെങ്കിൽ അങ്ങനെയാണ് സാർ. ഇപ്പൊ എന്താന്ന് വെച്ച് കഴിഞ്ഞാൽ ഈ ലിക്വിഡേറ്റർ എന്ന് പറയുന്നത് തന്നെ ഒരു പ്രൊഫഷണൽസ് ആണ് വരുന്നത്. ഇതിൽ പറഞ്ഞതനുസരിച്ച് വരുമ്പോൾ നമ്മൾ മുമ്പുള്ളതുപോലെ ഒഫീഷ്യൽ ലിക്വിഡേറ്റർ എന്നുള്ള ഒരു കോൺസെപ്റ്റിന് വ്യത്യാസമായിട്ട് വന്നിട്ടുണ്ട്. ഇവിടെ ഇപ്പൊ എന്താ നടക്കുന്നതെന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ ആദ്യം ഈ കമ്പനി വയബിൾ ആയിട്ടുള്ള ഒരു ബിസിനസ് ആണെങ്കിൽ, അതായത് ബിസിനസ് കൊണ്ടുപോകാൻ പറ്റുകയാണെങ്കിൽ മാക്സിമം അതിനെ കൊണ്ടുപോകാൻ പറ്റുന്ന രീതിയിലാണ് ലോ ഉണ്ടാക്കിയിട്ടുള്ളത്. അതായത് അതിനെ പ്രൊമോട്ട് ചെയ്യുന്ന രീതി, അല്ലെങ്കിൽ ആ ബിസിനസ്സിനെ വേറെ ആർക്കെങ്കിലും വാങ്ങാൻ സാധിക്കുമെങ്കിൽ ആ കമ്പനീനെ ആ രീതിയിൽ. അപ്പം ചുരുക്കി പറഞ്ഞു കഴിഞ്ഞാൽ ആ ബിസിനസ്സിനെ തകർക്കാതെ എന്നാൽ അതിൻ്റെ അകത്ത് കെട്ടിക്കിടക്കുന്ന എന്തെങ്കിലും അസറ്റ്സ് ഉണ്ടെങ്കിൽ അതിനെ സേവ് ചെയ്തുകൊണ്ട് പോകാൻ പറ്റുമോ എന്നുള്ളതാണ് നോക്കുന്നുള്ളത്. അതാകുമ്പം അവിടെ അതിലുള്ള ഡിഫറെന്റ് സ്റ്റേക്ക് ഹോൾഡേഴ്സിനെ അത് ബാധിക്കില്ല, ബിസിനസ് മുമ്പോട്ട് പോകും. അതേസമയം ഈ ബിസിനസ് തന്നെ മുമ്പോട്ട് പോകാൻ പറ്റാത്ത ഒരു സിറ്റുവേഷൻ ആണെന്നുണ്ടെങ്കിൽ അപ്പൊ അതിലുള്ള അസറ്റ്സ് എന്തെങ്കിലും അതിൽ കെട്ടിക്കിടക്കുന്ന പണവും കാര്യങ്ങളും, അതായത് അസറ്റ്സ് ആയിട്ടുള്ളതിന് എങ്ങനെയെങ്കിലും അതിൽ നിന്ന് റിലീസ് ചെയ്യാനാണ് ശ്രമിക്കുന്നത്. അപ്പൊ അതുകൊണ്ടാണ് അൺവയബിൾ ആയിട്ടുള്ള ഒരു ബിസിനസ് ആണെങ്കിൽ അത് അവിടെ നിർത്തുന്നതാണ് എന്തുകൊണ്ടും എല്ലാവർക്കും നല്ലത്. അപ്പൊ അതിന് വേണ്ടിയിട്ടുള്ള ഒരു മെക്കാനിസം ആണ് ഈ ലോ വഴി നോക്കുന്നത്. അതല്ല ഇത് കണ്ടിന്യൂ ചെയ്യാൻ പറ്റുന്ന ഒരു ഓപ്ഷൻ ആണെങ്കിൽ വെറുതെ പോയി ലിക്വിഡേറ്റ് ചെയ്തിട്ട് പലതരത്തിലുള്ള ആൾക്കാർ ഇതിൻ്റെ അകത്ത് പെട്ടവരെ ഡിഫിക്കൽറ്റിയിൽ എത്തിക്കരുത്. അതായത് ഇപ്പം ഈ പറയുന്ന ക്രെഡിറ്റേഴ്സ് മാത്രമല്ല ഒരു കമ്പനിയെ സംബന്ധിച്ചിട്ടുണ്ടാവും, അതിൻ്റെ അകത്ത് വർക്ക് ചെയ്യുന്ന എംപ്ലോയീസ് ഉണ്ടാവും, പല ടൈപ്പ് ഓഫ് സ്റ്റേക്ക് ഹോൾഡേഴ്സ് ഉണ്ടാവും. അപ്പൊ അവരെ ഒന്നും ബാധിക്കാതിരിക്കണം എന്നുണ്ടെങ്കിൽ ആ ബിസിനസ് നല്ല രീതിയിൽ കണ്ടിന്യൂ ചെയ്യാൻ പറ്റുകയാണെങ്കിൽ അങ്ങനെ പോട്ടെ. പക്ഷെ അതിന് ഫിനാൻഷ്യൽ കൺസ്ട്രെയിൻസ് ഉണ്ടെങ്കിൽ വേറെ ആർക്കെങ്കിലും ആ കമ്പനീനെ വന്നിട്ട് വാങ്ങാൻ സാധിക്കും. അതൊരു ഒരു ഓപ്ഷനാണ്, അതായത് റെസൊല്യൂഷൻ ഉള്ള ഒരു ഓപ്ഷനാണ് ഈ കമ്പനീസിനെ വാങ്ങുക എന്നുള്ളത്. അല്ലെങ്കിൽ മറ്റു രീതിയിൽ ഫിനാൻസ് ചെയ്യുന്നതാവാം. അപ്പൊ അത്തരത്തിലുള്ള കാര്യങ്ങളെ പ്രൊമോട്ട് ചെയ്യാൻ വേണ്ടിയിട്ടാണ്, അതായത് ഈ ബിസിനസ്സിന് ഒരു ഗോയിങ് കൺസേൺ ആയിട്ട് കൊണ്ടുപോകാനാണ് ശ്രമിക്കുന്നത്. അതുകൊണ്ടാണ് ആ റെസൊല്യൂഷൻ എന്നുള്ളൊരു ഓപ്ഷൻ കൊടുക്കുന്നത്. പക്ഷെ അത് പറഞ്ഞുകൊണ്ട് ആ ഒരു റെസൊല്യൂഷൻ പ്രോസസ് കുറെ കാലം ഇങ്ങനെ നീണ്ടു നിൽക്കുകയാണെങ്കിൽ എഗെയിൻ അത് നമുക്ക് ഡിഫിക്കൽട്ട് ആവുകയുള്ളൂ. കാരണം എന്താ വെച്ചാൽ അതിന്റെ ഉള്ളിൽ കിടക്കുന്ന അസറ്റ്സിന്റെ വാല്യൂ ഓരോ വർഷം കഴിയുമ്പോഴും അത് ഇങ്ങനെ കുറഞ്ഞുകൊണ്ടിരിക്കുകയാണ് ചെയ്യുക. അവോയ്ഡ് ചെയ്യാൻ വേണ്ടിയിട്ടാണ് ഒരു ടൈം ലൈന് ഫിക്സ് ചെയ്തിട്ടുള്ളത്. അപ്പൊ നിങ്ങൾക്ക് വേണമെങ്കിൽ റിസോൾവ് ചെയ്യാം, അങ്ങനെയാണ് നിയമം പറയുന്നത്. റിസോൾവ് ചെയ്യാം പ്രൊവൈഡഡ് എന്താണ് ഈ പറയുന്ന ടൈം ഫ്രെയിമിനുള്ളിൽ അത് ചെയ്ത് തീർക്കണം. അത് ചെയ്ത് തീർക്കാൻ സാധിക്കുന്നില്ല എന്നാണെങ്കിൽ ഡെഫിനറ്റ്ലി സെക്കൻഡ് സ്റ്റേജ് എന്ന് പറഞ്ഞാൽ ഈ ലിക്വിഡേഷനിലേക്ക് പോകും. ലിക്വിഡേഷനിൽ പോകുമ്പോൾ എഗെയിൻ അതിന്റെ പ്രൊസീജിയർ വൈസ് നോക്കുകയാണെങ്കിൽ ഇതൊക്കെ ചെയ്ത് നടത്തുന്നത് ലിക്വിഡേറ്റർ ആണ്. സോ ഈ ലിക്വിഡേറ്റർ ഇതെല്ലാം ചെയ്തിട്ട് അതാണ് ഞാൻ ലാസ്റ്റ് പറഞ്ഞിരുന്ന ആ ഒരു പ്രോസസ്സിലേക്ക് എത്തുന്നത്. അവിടെയും ഒരു ഓപ്ഷൻ പിന്നീട് ഇതേപോലെ ലോയില് ഒരു പ്രൊവിഷൻ ഇൻക്ലൂഡ് ചെയ്തിട്ടുണ്ട്. ഈ ഒരു സിറ്റുവേഷനിലും ഇതൊരു ഗോയിങ് കൺസേൺ ആയിട്ട് പോകാൻ സാധിക്കുകയാണെങ്കിൽ, ഒരാൾ വന്ന് വാങ്ങാൻ റെഡി ആവുകയാണെങ്കിൽ യു ക്യാൻ ഗോ ഫോർ ദാറ്റ് എന്നാണ് പറയുന്നത്. അപ്പം ആ ലിക്വിഡേഷൻ പ്രോസസ് ഇനീഷ്യേറ്റ് ചെയ്തു എന്നതുകൊണ്ട് എന്ത് ചെയ്യുന്നില്ല, ആ പറയുന്ന ഒരു സേവ് ചെയ്യാൻ, ആ കമ്പനീനെ സേവ് ചെയ്യാൻ ഒരു ഓപ്ഷൻ കിട്ടിയിട്ടുണ്ടെങ്കിൽ അത് ചെയ്യാതിരിക്കാൻ, അതായത് പ്രൊസീജിയർ മാത്രം കൊണ്ട് അതിനെ ഒരു ഡിഫിക്കൽട്ട് ആയിട്ട് നിൽക്കാൻ പറ്റരുത്, ആ പ്രൊസീജിയർ ഒരു ഡിഫിക്കൽട്ട് സ്റ്റേജിലേക്ക് എത്തിക്കരുത്. അപ്പൊ അതുകൊണ്ടാണ് ഈവൻ ലിക്വിഡേഷൻ സ്റ്റേജിലും അങ്ങനെ ഒരു ഗോയിങ് കൺസേൺ സെയിൽ പോസിബിൾ ആണെങ്കിൽ, ഗോയിങ് കൺസേൺ സെയിൽ കൊണ്ട് ഉദ്ദേശിച്ചതാണ് ആ ബിസിനസ്സിനെ വാങ്ങാൻ, ബിസിനസ് ആയിട്ട് കണ്ടിന്യൂ ചെയ്യാനുള്ള രീതിയിൽ ഒരാൾ വന്നിട്ടുണ്ടെങ്കിൽ അതിനെ പ്രൊമോട്ട് ചെയ്യണം എന്നുള്ള പറയുന്നത്.
താങ്ക് യു മാഡം.
ഇൻഡിവിജ്വൽ ഇൻസോൾവൻസിന്റെ വ്യത്യാസമാണ്. ഇപ്പോഴും നമുക്ക് എന്താണ് ചെയ്യുന്നതെന്ന് പറഞ്ഞാൽ ഇപ്പോഴും പ്രൊവിൻഷ്യൽ ഇൻസോൾവൻസി ആക്ടും പ്രസിഡൻസി ഇൻസോൾവൻസി റൗണ്ട്സ് ആക്ട് ഒക്കെ തന്നെയാണ് നമ്മൾ ഇപ്പോഴും ഫോളോ ചെയ്യുന്നത്. കാര്യം എന്താന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ അതിൽ നോട്ടിഫൈ ചെയ്തിട്ടില്ല. ഇപ്പോഴും നോട്ടിഫൈ ചെയ്തത് ഒരു ഭാഗം മാത്രമേ ഉള്ളൂ. അതിപ്പോ 2019 നോട്ടിഫൈ ചെയ്തിട്ടുള്ളൂ. ഈ കോർപ്പറേറ്റ്സിനെ സംബന്ധിച്ച് കോർപ്പറേറ്റ്സിന് പേഴ്സണൽ ഗ്യാരണ്ടീസ്, അതായത് ഷുവർട്ടീസ് ആയിട്ട് നിൽക്കുന്ന ആൾക്കാരുണ്ടല്ലോ കോർപ്പറേറ്റ്സിന്റെ, അവരുടെ കേസിൽ വരുമ്പോൾ മാത്രമാണ് ഈ ഇൻഡിവിജ്വൽ ഇൻസോൾവൻസി നോട്ടിഫൈ ചെയ്തിട്ടുള്ളത്. അതും ഈ പറയുന്ന പോലെ കമ്പനി ആയിട്ടുള്ള രീതിയിൽ പ്രൊസീഡിങ്സ് കാര്യങ്ങൾ എന്തെങ്കിലും നിൽക്കുന്നുണ്ടെങ്കിൽ അത് ഡെഫിനറ്റ്ലി ഇതിൽ തന്നെയാണ് പോവുക. അതായത് കോർപ്പറേറ്റ് ഇൻസോൾവൻസിന്റെ പ്രൊവിഷൻസ് അനുസരിച്ച് തന്നെയാണ് പോവുക. അതായത് NCLT നിൽക്കും. അതേസമയം ഇതിൽ നിന്ന് വ്യത്യസ്തമായിട്ട് നിൽക്കുന്ന ഒരാളാണെന്നുണ്ടെങ്കിൽ അല്ലെങ്കിൽ വേറിട്ട് നിൽക്കുന്ന ഒരാളാണെങ്കിൽ ബട്ട് ദാറ്റ് പെർട്ടിക്കുലർ പേഴ്സൺ ഇസ് കോർപ്പറേറ്റ്, അതായത് ഹീസ് എ ഷ്യൂരിറ്റി ടു ദിസ് പെർട്ടിക്കുലർ കോർപ്പറേറ്റ്, അങ്ങനെയാണെങ്കിൽ DRTയിലെ പ്രൊവിഷൻസ്, അതായത് DRTയിലാണ് ഇത് കൺസിഡർ ചെയ്യാൻ നോക്കുക. അപ്പം ഇൻഡിവിജ്വൽ ഇൻസോൾവൻസിയിലെ പ്രൊവിഷൻസ് ആണ് നോക്കുക. അത് ഇപ്പം നമ്മൾ ഡിസ്കസ് ചെയ്തതിൽ നിന്നും കുറച്ച് വ്യത്യസ്തമാണ്. അപ്പൊ അതാണ് ഇൻഡിവിജ്വൽ ഇൻസോൾവൻസിന്റെ ഭാഗത്ത് ഇപ്പം നിലവിൽ നോട്ടിഫൈ ചെയ്തിട്ടുള്ളത്. അത് മാത്രമേ ഉള്ളൂ. ബാക്കിയെല്ലാം നമ്മൾ പഴയ സിസ്റ്റം തന്നെയാണ് ഫോളോ ചെയ്യുന്നത്. വൺസ് ദിസ് ഇസ് നോട്ടിഫൈഡ്, ഈ പ്രസിഡൻസി ടൗൺസ് ആക്ടും പ്രൊവിൻഷ്യൽ ഇൻസോൾവൻസി ആക്ട് ഒക്കെ റിപ്പീൽ ചെയ്യപ്പെടുകയാണ് ചെയ്യുക. അങ്ങനെയാണ് ലോന്റെ പൊസിഷൻ ഉള്ളത്.
താങ്ക് യു മാഡം. താങ്ക് യു.
പിന്നെ അതേപോലെ നമ്മളിപ്പം NCLT വേറെയും കുറെ പവേഴ്സ് ഇതിൽ കൊടുത്തിട്ടുണ്ട്. ഇപ്പം ഫോർ എക്സാമ്പിൾ ഈ പറയുന്ന ഡിസ്പ്യൂട്ട്സിന്റെ ഇടയ്ക്ക് തന്നെ, അതായത് നമ്മൾ ഈ പറഞ്ഞ പ്രോസസ്സ് നടക്കുന്നതിന്റെ ഇടയിൽ തന്നെ, ഫോർ എക്സാമ്പിൾ ഇഫ് ഈ പറയുന്ന കമ്പനീന്റെ അസറ്റ്സ് ഒക്കെ മറ്റു രീതിയിൽ എന്തിനെങ്കിലും കേസുകളോ കാര്യങ്ങളോ സ്യൂട്ട്സോ ആയിട്ടുണ്ടെങ്കിൽ അതും NCLTക്ക് കൺസിഡർ ചെയ്യാന്ന് പറഞ്ഞിട്ടൊരു പ്രൊവിഷൻ പറയുന്നുണ്ട്. ഇപ്പൊ ചുരുക്കി പറഞ്ഞു കഴിഞ്ഞാൽ ഈ ഒരു എക്സ്ക്ലൂസീവ് ജൂറിസ്ഡിക്ഷൻ എന്നുള്ള രീതിയിലായിട്ട് മാറുകയാണ് ചെയ്യുന്നത് ഈ പറയുന്ന ലോ. ഇപ്പം NCLT, അവിടുന്ന് NCLAT, പിന്നെ സുപ്രീം കോർട്ട്, ഈ രീതിയിലാണ് ഇതിന്റെ ഒരു ഹൈറാർക്കി വരുന്നത്.
ഈ NCLATയും NCLTയും എല്ലാ സ്റ്റേറ്റ്സിനും ഉണ്ടോ?
ഒരുവിധം ഉണ്ട് സർ. ഇപ്പം ഓൾ ടുഗെദർ ഐ തിങ്ക് 16 ബെഞ്ചസ് ആണ്, പ്രിൻസിപ്പൽ ബെഞ്ച് അടക്കം ഉള്ളത്. ഇപ്പൊ നമുക്ക് റീസെന്റ് ഇപ്പം നമ്മൾ ഇതിൽ പറയുകയാണെങ്കിൽ ചെന്നൈയിലായിരുന്നു ആദ്യം ജൂറിസ്ഡിക്ഷൻ ഉണ്ടായിരുന്നത്. ഇപ്പം കൊച്ചിയിലും സ്റ്റാർട്ട് ചെയ്തിട്ടുണ്ട്, ബെഞ്ച് ഉണ്ടല്ലോ.
I can ask one more question, madam. The consumer forum passed an award against the Israeli equipment finance company. By the time check reached for collection, it declared as a bankrupt. Then filed a petition before the consumer forum that we are declared a bankrupt, therefore we are not in a position to comply the award. So what is the position, madam? A check issued before bankruptcy proceedings, once it reached for collection, by the time its validity also expired, then company contends that we are not liable, we are prohibited from making any payment due to the bankruptcy proceedings.
Okay,
so what is the remedy of the complainant in the consumer case?
Okay, sir. So the thing is that the insolvency law has an overriding effect, sir. But so the thing, it is like this. When there comes any clash between any other laws, the law of the procedures under insolvency law would be prevailing. So there is a provision wherein it says that it is so. Apart from that, if it is with respect to claims, when it comes to the case of whether it be resolution or for liquidation, there is a stage wherein the claims are called for. That is, the insolvency professional can call for the claims. So some kind of timelines has also been laid down. So within that particular prescribed timelines, we have to make if we have any kind of claims, we have to approach them. Again, like I've mentioned, even at the stage of liquidation also, certain there is a time wherein we can give our claims. So once that time is lapsed, then it would be difficult for us to claim for the same. So two things, sir, from your question. One is with respect to the effect of this particular law is that it is having an overriding effect. So definitely the procedures and the things under insolvency law would prevail over the other things. Second thing is that with respect to claims, that is the provisions have been made under the code that claims would be called for. So at that particular time, if we have claims, we'll have to approach. If not, it would be difficult then. Hope that is clear, sir.
Yes.
No one else has any more questions. Shall we wind up the session?
Yes, wind up.
So thank you, Advocate Shruthi Manohar, for this very enlightening talk on a very different subject. All of us are still suffering from the hangover of the Insolvency Act. That is why questions as to the individual bankruptcy, individual ഒരാളെ ഇൻസോൾവെന്റ് ആയി കഴിഞ്ഞാൽ അയാളുടെ ഡെറ്റ്സിൽ നിന്നും അയാൾ അറസ്റ്റ് ചെയ്യാൻ പറ്റില്ല. That is the basic concept we have. But since the new bankruptcy code has come, the insolvency and bankruptcy code has come, അതിന്റെ കൂടുതൽ ഇപ്പോഴും കോർപ്പറേറ്റ് എംഫസിസ് ആണ് ഉള്ളത്. Even now, I think it was news to me that only certain portions of individual bankruptcy have been notified and nothing else is said. So thank you very much. I'm sure everyone who listened has gained something valuable. With the permission of the audience, I propose a vote of thanks to the speaker, and let us conclude for the day. Thank you very much.
Thank you, sir.
Thank all the participants for being here. CUSAT wind up here.